The Denver City and County Building stands at 1437 Bannock Street, on the western edge of the Civic Center, with a granite facade and a clock tower that Denver lights green at Christmas. Family Court Division 4 sits on the 4th floor in a courtroom about the size of a large suburban living room. There is a flag of the United States to the right of the bench, a flag of the state of Colorado to the left, and a Lexan partition between the gallery and the well that has not been removed since the pandemic. On the morning of April 18, 2024, a Thursday, my ex-husband, Jeremy Webb, sat at the petitioner's table in courtroom 4C in a slate gray suit he had bought the week before at the Nordstrom in Cherry Creek. His attorney, Dean Rubin, was beside him in dark navy. They were prepared for a hearing on an emergency motion to modify parenting time, which Jeremy had filed in early March, asking the court to grant him sole custody of our 2 children, Cole, who was 8, and Hannah, who was 4. I sat at the respondent's table in a Navy suit and the Air Force Academy class ring that no one in that courtroom except my attorney recognized. My attorney was a 62-year-old retired lieutenant colonel named Marcus Whitehorn, who had practiced family law in Denver since 2010 after 22 years as a judge advocate general officer in the United States Air Force. The hearing lasted 23 minutes. Jeremy testified for 14 of them about my unstable schedule, my refusal to disclose my travel, the parade of nannies I supposedly left the children with, and what he called my pattern of disappearing for 1 to 3 weeks at a time, without explanation. He told the court I was secretive about my employment, that I was vague about where I worked, and that I had refused, even during the marriage, to allow him to come to my office on the base. When he was done, the Honorable Angela Tesmer asked Jeremy a single question. The question lasted 23 seconds. Jeremy's answer lasted 3. The case ended 14 seconds after that. I want to tell you what was inside the sealed envelope Judge Tesmer had read in her chambers at 9:14 that morning, 26 minutes before she took the bench. I want to tell you who Colonel David Reyes was. I want to tell you why I had not disclosed my employer to my own ex-husband for the 8 years of our marriage. And I want to tell you, finally, what Dean Rubin said to his client in the elevator at 11:47 a.m. on April 18, 2024. I commissioned out of the United States Air Force Academy in Colorado Springs in May of 2009. My career field was 14N, intelligence officer. After 15 months at Goodfellow Air Force Base in San Angelo, Texas, for technical training, I PCSE'd to Wright-Patterson Air Force Base in Ohio in late 2010, and was assigned to the 88th Intelligence Squadron at the National Air and Space Intelligence Center. I met Jeremy Webb at the Hangar Bar in downtown Dayton in February of 2013, on a Friday night I had not particularly want to go out on. He was 28, 2 years older than me, a Wright State undergrad, with an MBA from the University of Cincinnati. Working as a junior financial analyst at a regional wealth management firm in Centerville, he was tall, he was funny. He had a careful way of asking questions about my job that I read at the time as polite, and that I would later, 10 years and 1 custody motion later, recognize as an early form of his curiosity. What I told him about my work was true and incomplete, in the way every line officer's explanations are true and incomplete to a civilian. I told him I was an Air Force intelligence officer. I told him I worked at NASIC. I told him my work was mostly desk work. I told him I traveled occasionally for interagency coordination meetings. I did not tell him my clearance level. I did not tell him the names of any units I supported. I did not tell him I was, by the spring of 2013, on the cleared roster for a particular type of analytical product that nobody outside a specific building at Fort Meade had ever heard of. We were married on September 27, 2014, in a small ceremony at a country inn in Yellow Springs, Ohio, with 31 guests. My commanding officer at NASIC came in his service dress. Jeremy's parents came up from Cincinnati. We honeymooned for a week in Asheville, North Carolina. I was 27. I had been in uniform for 5.5 years. I was ranked first lieutenant, 2.5 years away from making captain. Jeremy understood, on the day of the wedding, that I was going to PCS again at some point. He told me he was prepared to follow my career. He used those words. He said, "Sarah, your career is the career. We will follow it." I believed him because I wanted to believe him. And because at 27, you still believe most of what people you love tell you about themselves. I PC'd to Buckley Space Force Base in Aurora, Colorado, in June of 2018. By then I had pinned on captain. Cole was 18 months old. Jeremy had transferred internally with his firm to a Denver office in Greenwood Village and was managing accounts for a roster of high-net-worth clients along the Front Range. He never made the move feel like a sacrifice. He was, in the early years of our marriage, a kind man with a generous instinct and a real talent for being a father. My new assignment at Buckley was at the 544th Intelligence, Surveillance, and Reconnaissance Group, attached operationally to the 16th Air Force, which is the Air Force component of United States Cyber Command. I am not going to describe the work. I will tell you only that it required a higher clearance level than my previous billet, that it required regular TDY travel to Fort Meade, Maryland, and to several other locations, both inside and outside the continental United States, and that the assignments were authorized at echelons above the squadron and protected from disclosure under both DoD policy and federal law. On the day my orders cleared, in May of 2018, I sat down with Jeremy at the kitchen table in our rental in Beaver Creek, Ohio, and told him as much as I could legally tell him. I told him the unit. I told him the base. I told him that my travel was going to be classified, and that I was not going to be able to share my itineraries, my destinations, or in many cases, the duration of my trips in advance. I told him the children would always have a primary care arrangement during my TDYs. I told him my parents, who had retired to Aurora the previous year specifically to be near us when we PCS'd, would be the backup family caregivers. Jeremy nodded. He said the right things. He said, "Sarah, we will figure it out." We bought a house in the Stapleton Northfield development in Northeast Denver in August of 2018, 4 miles from the south gate of Buckley. Hannah was born in March of 2019 at Anschutz Medical Center on the University of Colorado campus. The first time I held her in the recovery room was 46 hours after I had returned from a TDY. I am not going to name on a clearance ticket I had walked out of the squad building at 4:14 a.m. that morning, still active. I did not tell Jeremy about the timing. I did not need to. He had been at the airport at 5:30 to pick me up. He drove me directly from baggage claim to my mother's house, where Cole was sleeping, and from there to the hospital, because Hannah had decided she was coming 6 days early. Marriages do not, in my experience, end on a single day. They end across a sequence of small refusals that, looked at one at a time, are nothing, and that, looked at all at once from the far side, are everything. Jeremy began drinking more in late 2019 and 2020. He never drank in the morning. He never drank around the children. He drank in a controlled, persistent, after 9 p.m. way that read as a hobby until it read as an architecture. He began complaining, first occasionally and then weekly, about the fact that I could not tell him where I had been or for how long. He used the phrase living with a stranger first in October of 2019, in a tone he framed as a joke. By the spring of 2021, he was using it without the framing. What had not changed in any of those months was the structure of the work itself. I had not asked for more travel. I had not chosen to be assigned to a higher tempo billet. I had executed the orders the Air Force had given me, with the cadence the unit operated on, and I had organized my life around the children and around the windows of time I was home. When I was home, I was home. I made dinner. I read books at bedtime. I did the school pickups when the calendar permitted. I was not, by any measure I or the Air Force or the children themselves applied, an absent mother. I was a mother who, 2 or 3 weeks out of every quarter, was in another time zone, working on something I could not bring home. Jeremy filed for divorce on June 14, 2021. The petition cited irreconcilable differences. He requested joint legal and joint physical custody under a customary Colorado parenting plan and a roughly 50-50 division of marital assets. He did not, in 2021, ask for sole custody. He did not, in 2021, suggest I was unfit. He told my parents, when they asked him directly at a dinner my mother organized in July to try to talk it through, that he loved the children and respected me, and was simply unable to continue in a marriage he found, in his phrase, parallel rather than shared. We finalized the divorce on October 8, 2021. The decree provided for joint legal and joint physical custody under a 2-2-3 parenting time schedule, with the children alternating between our 2 households on a weekly cycle. The Northfield house was sold the following spring. Jeremy bought a townhouse in Stapleton, 12 minutes from my new house in Park Hill. The schedule worked. For 2 years and 3 months, the schedule worked. Jeremy met Tabitha Rubin on a Friday night in June of 2023 at a rooftop bar in Rhino, the kind of repurposed warehouse establishment. Denver has been opening at the rate of 3 a year since the city stopped being unfashionable. She was 35, blonde, divorced, no children of her own, with a corporate events business based out of the tech center, and an older brother named Dean Rubin. Dean Rubin is 43, partner at a 6-attorney family law firm in lower downtown, Colorado College undergrad, University of Denver Law class of 2007. He has a good reputation for aggressive parenting time litigation. He is also, my mother would say if asked, the kind of attorney whose website has slightly too many pictures of him on it. Tabitha moved into Jeremy's townhouse in November of 2023. By the time the children met her, on a Saturday in early December, she had been a part of his daily life for 5 months. She was, at first, perfectly fine with them. Hannah liked her. Coal was reserved in the way coal is reserved with anyone who is not me or his grandparents. The children spent 4 weekends in Tabitha's presence between Thanksgiving and the end of January, on Jeremy's parenting time, before either of them mentioned her to me. What I learned later from Cole, who is observant in the way only quiet 8-year-olds are observant, was that during those weekends, Tabitha asked the children certain questions. She asked them whether their mommy was at home a lot. She asked them whether they were ever scared when their mommy was gone. She asked them whether they liked staying at their grandma's house. She asked them whether their mommy ever missed birthdays or important things. Cole, who has known since he was 4 that he is supposed to be careful about questions. Adults ask about my work, gave Tabitha clean and uninformative answers. Hannah, who was 4.5, told her one Sunday afternoon, with the matter-of-fact frankness of a small child, that her mommy went on airplanes for her job, and sometimes was gone for a long time, and that Grandma's house had a tire swing. By February of 2024, Jeremy had retained Dean Rubin. The motion was filed on March 4. The hearing date was set for April 18. I was served at my front door in Park Hill on a Wednesday evening in early March, while a sheet pan of roasted vegetables was finishing in the oven, and Hannah was upstairs, FaceTiming my mother about a missing stuffed rabbit. I read the petition standing in my entryway. The petition described me as living a life characterized by, in its phrasing, repeated, prolonged, and unexplained absences, during which the minor children are placed in the care of unrelated nannies and elderly grandparents. I closed the door. I called Marcus Whitehorn the next morning at 8:02 a.m. Marcus Whitehorn's law office is on the second floor of a 1908 brick building on East 17th Avenue near City Park, with a stained glass transom above the door that reads, in green and amber leaded glass, J. Peterson, Notary, 1908. Marcus did not put his name on the door. He had inherited the office and the transom together when he bought the practice in 2010, 2 months after his retirement from the Air Force JAG Corps. As a lieutenant colonel, he was 62 when I met him. He had grown up in Cheyenne, Wyoming, gone to the Air Force Academy in 1980, served 22 years on active duty, finished his career as the staff judge advocate at Travis Air Force Base in California, and started practicing family law in Denver because, as he told me at our first meeting, he was tired of arguing with majors and wanted to start arguing with people who at least had to look him in the eye. I sat across from him at a wooden desk on March 7, 2024, in a sweater and the same academy ring I had worn since 2009. I told him the entire story in about an hour. I told him about Jeremy. I told him about the work. I told him about the parenting plan. I told him about Tabitha. I gave him the petition. I gave him my orders, redacted at the line my staff judge advocate had told me I was allowed to redact at. I gave him the names and titles of my chain of command up to the wing commander. Marcus listened without interrupting. When I was done, he said, "Captain Webb, may I ask you something?" I said, "Yes, Colonel," he said. "Has Mr. Webb, in any of his communications with you, or with the children, or with Mr. Rubin, that you are aware of, accurately described or your employers as the United States Air Force?" I said, "He has described me to friends as working as a civilian analyst at a defense contractor. I have heard him use the phrase from time to time. I do not know what he has told Mr. Rubin. Marcus closed the manila folder on his desk. He said, "All right. The petition references Captain Webb's employer, a defense industry company. That is the phrase used in paragraph 14. Mr. Rubin either took that phrasing from his client without verification, or his client provided it to him knowingly. We will have a chance to clarify it. The mechanism is going to be TUHI." I did not know what TUHI was, Marcus told me. TUHI is shorthand in federal practice for a 1951 Supreme Court case called United States ex rel. TUHI v. Ragan. The case held that federal employees can be required by their agencies to refuse to disclose certain information in response to subpoenas or court orders, and that the agency's decision controls. In the years since, every federal department has issued its own implementing regulations, all of which are referred to in shorthand as that department's TUHI regulations. The Department of Defense TUHI regulations are codified at 32 CFR Part 516. What Marcus Whitehorn understood, and what Dean Rubin either did not understand or had not bothered to research, is that 32 CFR Part 516 also provides a controlled mechanism for the Department of Defense to affirm certain facts about an active duty service member's employment status, duty location, and the lawful nature of their assignments, in a sealed communication to a state court, when the affirmation of those facts is necessary to resolve a matter, and disclosure of the underlying details would compromise national security. The mechanism is initiated by the service member's staff judge advocate. It is reviewed up the JAG chain. It produces a sealed letter delivered directly from the responsible JAG to the presiding judge. Marcus walked me through the request on the same afternoon. I drove out to Buckley the next morning and met with my staff judge advocate, Major Christine Holroyd. Major Holroyd reviewed the petition, the parenting plan, and Marcus's memorandum. She said, "Captain Webb, we can do this. The wing commander will sign. The turnaround on a custody hearing is fast-tracked. Your hearing is April 18. The letter will be at the courthouse by April 17. On March 18, 2024, my commanding officer, Colonel David Reyes, signed a request for a TUI mechanism letter on my behalf. Colonel Reyes is 51. Born in San Antonio, USAFA class of 1995, 3 deployments to the AFRICOM area of responsibility. Presently, the Operations Group Commander at the 544th ISR Group. He has a daughter at the Academy and a son in 8th grade. He is the kind of officer who does not waste his signature. On April 16, 2024, 2 days before the hearing, the sealed letter was hand-delivered to the courtroom clerk for Judge Angela Tesmer in Division 4 of the Denver Family Court. The transmittal form identified the letter as a Department of Defense TUHI submission to the court regarding the matter of Webb v. Webb custody modification motion. The letter was placed in a sealed envelope. The envelope was placed in chambers. Judge Tesmer opened the envelope at 9:14 a.m. on April 18, 2024, 26 minutes before she took the bench. Court was called to order at 9:40 a.m. The bailiff was a tall woman named Ophelia Garcia, who had been at the Denver Family Court for 19 years, and who, my mother told me later, recognized the Academy ring on my hand when I rose for the bench and gave me the smallest possible nod. Judge Angela Tesmer is 58. She had been a domestic relations magistrate for 11 years before her appointment to the district bench in 2019. She is the daughter of a Vietnam War helicopter pilot. Her father had served in the 174th Assault Helicopter Company in 1970 and 1971. She had grown up, as Marcus would tell me later, in the elevator on the way down, in a house where the word deployment was not theoretical and where the schedule of a parent in uniform was not a matter that a civilian got to second-guess from a Cherry Creek law office. Dean Rubin opened. He framed the motion as a child welfare matter. He said his client's primary concern was the stability of the children's home environment, given what he characterized as Captain Webb's pattern of unexplained, unverifiable, and prolonged absences. He used the phrase pattern of unexplained absences 4 times in his opening. He said the children deserved a primary residence with a parent whose schedule was predictable, transparent, and consistent. Then he called Jeremy. Jeremy was sworn in. He took the stand at 9:48. He spoke for 14 minutes. He covered, in order, my pattern of travel since 2018, the duration of my longest TDYs, which he overestimated in the way a frustrated spouse will overestimate by approximately 50% the children's reliance on my parents and on a part-time after-school nanny named Lupita Calvillo, who had been with our family since 2019, what he called my secrecy about my employer, and his concern that the schedule was not sustainable for school-age children. He testified in the same registered emotional key throughout, with the calm confidence of a man who believed he was telling the truth. He did not know, when he stepped down from the witness chair at 10:02 a.m., that Judge Tesmer had read a sealed letter 48 minutes earlier that contained, on a single page of letterhead from the Office of the Staff Judge Advocate, 21st Space Wing, Buckley Space Force Base, the affirmation that Captain Sarah Marie Webb was an active duty officer of the United States Air Force, that her employer was the United States Department of the Air Force, that her assignments were lawful and authorized, and that her travel during the period referenced in the motion had been conducted under valid orders, the disclosure of which was protected from compulsory process under federal law. Dean Rubin rested. Marcus Whitehorn rose. He said, very simply, Your Honor, the respondent reserves cross-examination of the petitioner pending the court's consideration of the sealed submission filed in chambers on April 16th. Judge Angela Tesmer set down her pen. She looked across the courtroom at Jeremy Webb, who was returning to the petitioner's table. She looked at Dean Rubin, who was already preparing his closing notes. She looked at the gallery, which contained my mother in the second row, my father beside her, and my squadron section commander, Major Adam Klein, in the third row in service dress. Marcus had asked Major Klein to attend in uniform as a courtesy to the court. He had attended on his lunch hour. Judge Tesmer addressed Jeremy. She said, Mr. Webb, before we proceed any further, I have one question for you. Please answer carefully and under the oath you took at 9:48. Jeremy said, Yes, Your Honor. Judge Tesmer said, Mr. Webb, in your petition filed March 4, 2024, you describe your former wife, the respondent in this matter, as employed by, in the language of paragraph 14, a defense industry company. You repeated this characterization in substance in your direct testimony this morning at approximately 9:51 a.m., Mr. Webb. Do you have, today, in this courtroom, any reasonable belief that the respondent is a civilian employee of a private defense contractor, as opposed to an active duty commissioned officer of the United States Air Force. The courtroom was silent. Jeremy looked at Dean Rubin. Dean Rubin did not look back at him. Dean Rubin was looking at Judge Tesmer with the careful expression of a man who has just understood something he should have understood 3 weeks ago. Jeremy said, I knew she was in the Air Force, Your Honor. I think I may have used imprecise language in the petition. Judge Tesmer said, Mr. Webb, whose language was it? Jeremy said, It was discussed with my counsel, Your Honor. Judge Tesmer turned to Dean Rubin. She said, Counselor. The court reads the sealed submission filed by the Office of the Staff Judge Advocate at Buckley Space Force Base on April 16th. The submission affirms that Captain Sarah Marie Webb is, and has continuously been since 2009, an active duty commissioned officer of the United States Air Force, presently assigned to the 544th Intelligence, Surveillance, and Reconnaissance Group. The submission further affirms that the travel described in your client's petition was conducted under valid orders, that the duration and nature of those orders are protected from compulsory disclosure under 32 CFR Part 516, and that no aspect of Captain Webb's service represents a deviation from any duty owed by a parent to a child under Colorado law. She said, The court takes judicial notice of the submission. She said, Counselor, do you wish, on behalf of your client, to be heard before this court rules on the motion as filed? Dean Rubin rose. He said, Your Honor, the petitioner respectfully withdraws the motion to modify parenting time without prejudice. Judge Tesmer said, The motion is withdrawn. Petitioner shall pay respondents reasonable attorney fees in connection with the motion, in an amount to be determined by submission of fees within 30 days. The 223 parenting plan, as established in the original decree, shall remain in effect. Court is adjourned. She brought down her gavel. Marcus Whitehorn and I left courtroom 4C at 11:42 a.m. We took the elevator down with my mother and father. The elevator made its slow descent past the 3rd floor, then the 2nd, then the 1st. The doors opened on the lobby. As we were stepping out, Dean Rubin and Jeremy were stepping into the adjacent elevator, on their way down from a brief consultation room they had retreated to after the gavel. What I heard through the gap between the 2 elevator banks, in the 4 seconds before both doors closed, was Dean Rubin saying to Jeremy, in the quiet professional voice attorneys use when they are no longer trying to win something, Jeremy, you should have told me what she actually did. We could have had a different conversation in February. I am going to bill you for this morning, and I am going to recommend you find a different attorney for anything that comes after this. We are done. My mother, who has been retired from her family medicine practice in Colorado Springs for 12 years, and who reads people the way she used to read EKGs, took my arm as we crossed the lobby. She said very softly, Sarah, he never asked. In 10 years he never asked. I did not say anything. I was thinking at Cole and Hannah. They were at school. Cole was in 3rd grade at Stedman Elementary in Park Hill, learning long division that week. Hannah was at the preschool at Park Hill United Methodist on Montview Boulevard, working on letter recognition. Neither of them knew what had happened in courtroom 4C. Neither of them ever needed to know, in the same level of detail, what their father had attempted on a Thursday morning in April when they were 8 and 4. What I would tell them, eventually, in the way you tell children the things they should know about their family, was simpler. I would tell them that their father had loved them and had also been hurt by some things he had not understood about my work, and that a judge in Denver had decided on a morning when they were both at school that the schedule we had was the right schedule. I would not tell them until one of them was in college about the sealed letter I pinned on Major in October of 2024. The promotion ceremony was held at the Squadron building on Buckley on a Friday afternoon with my parents, the children, and my squadron commander, Lieutenant Colonel Patricia Okonkwo, present. My oath of office was administered by Colonel David Reyes. Cole, who was 9 by then, asked me at the reception afterward whether I now had the same number of stripes as Grandpa, who had been an enlisted Marine in the early 1980s. I told him my insignia worked differently and explained the bars and oak leaves over a piece of cake. Jeremy paid the attorney fee award in May of 2024. He paid it without further dispute. He took 12 weeks off from his firm in early 2025, a leave I learned about from Cole, who mentioned that Daddy was at home a lot and entered an outpatient program in Cherry Creek to address his drinking. He has, as of the writing of this account, been sober for 11 months. He and Tabitha separated in September of 2025. He has not asked, since April of 2024, about my schedule. He has, on the other hand, been more present with the children than he was at any point during our marriage. He picks Cole up from school on his weeks. He attends Hannah's pre-K Friday performances. He writes me one short email per quarter that begins, almost always, with the word Sarah, just confirming pickup on Friday at 5:30. Nothing else. Marcus Whitehorn retired from active practice in June of 2025. He did not close the office on East 17th Avenue. He sold the practice to a younger attorney named Diana Trujillo, who had clerked for the 10th Circuit, and who, Marcus told me, at the small retirement reception he held at the Cherry Cricket on East 2nd Avenue, would be a better attorney than he had ever been. He gave me his Air Force Academy class ring as a parting gift. He had 2. He said the second one belonged to the next intelligence officer, who walked into the office on East 17th Avenue with a custody petition in her hand. He said he did not need both anymore. It is November of 2025 as I finish this account. I am sitting at the kitchen table in my house in Park Hill in northeast Denver. The mountains, which on most clear afternoons in the fall you can see from the upstairs window, are dusted lightly with the first snow. Cole is doing his 5th grade math homework at the dining table. Hannah is on the floor of the living room with 3 plastic horses and an elaborate narrative I am not currently following. The Academy ring on my hand is the one I commissioned with in 2009. The second ring, the one Marcus Whitehorn gave me in June, is in a small wooden box on the shelf above my desk, waiting for the next intelligence officer. The sealed letter from the Office of the Staff Judge Advocate is by federal regulation still sealed. The original is filed in the court record under restricted access. A certified copy is in a safe at the Wing Legal Office at Buckley. I have never been shown the document myself. I do not need to see it. What it said, I already know. It said what every Tuhi mechanism letter written has said in its various wordings, which is, in essence, Your Honor, this person works for us. Their work is lawful. We cannot tell you the rest. Please decide your case on the facts you have. Judge Angela Tesmer decided her case on the facts she had. The fact she needed was that Captain Sarah Marie Webb was, on the morning of April 18, 2024, a commissioned officer of the United States Air Force, and that her travel had been ordered, lawful, and protected. The rest of Jeremy's case dissolved against that fact the way a sandcastle dissolves at high tide. I was asked by a friend at the squadron reception after my October 2024 pin-on whether the morning in courtroom 4C had felt like a vindication. I have thought about that word. The honest answer is no. It had not felt like vindication. Vindication is what you feel when you have been arguing with somebody for a long time and you finally win the argument. I had not been arguing about my work for 10 years. I had been silent about it for 10 years. On purpose, under federal law and under personal preference, and the silence had been a kind of love during the marriage and a kind of dignity after the divorce. And what happened in April of 2024 was that the silence was placed, finally, in the only forum where it could be allowed to speak. The forum was a sealed envelope on a Tuesday afternoon in chambers. The voice was Colonel David Reyes' signature, transmitted through the Jaggi chain to a state court judge whose father had flown helicopters in 1971. What my ex-husband Jeremy Webb misjudged, in the end, was not me. He had me approximately right. He misjudged the system that stood behind me. He had assumed, as many civilian spouses of officers assume, that the United States military's interest in a custody dispute was zero. He had assumed that the lack of disclosure he had complained about at home would translate in a courtroom into a lack of evidence on the record. He had assumed that the Air Force would, in the phrase Marcus used in the elevator, stay out of his lane. He did not understand that the Air Force was already in the lane. The Air Force is always in the lane. The mechanism for affirming an officer's service to a state court is approximately 75 years old. It runs through a chain of signatures from a staff judge advocate to a wing commander to a JAG officer at headquarters and onto the desk of a presiding judge in a sealed envelope. It does not wait for a subpoena. It does not require a hearing. It is filed when the matter requires it, and not before. It had been filed for me. It would be filed for the next officer who needs it. That is the part of the story I want my children to know. When they are old enough to understand the shape of the institution that has employed me their entire lives, the institution, when it is functioning correctly, takes care of its own. Quietly, through the proper channels, without spectacle, on a Tuesday afternoon, in a sealed envelope addressed to a judge in Division 4 of the Denver Family Court.